There are some absolutely ridiculous disputes out there. And the headline was, "This is us when legal call us in for a little chat."
I think when he does it, you just
there's a
go
video
like
on the IPO for it. It was just Jess Glynn on hold for about 4 hours.
Like, he is unique. He's massive.
Yeah.
Balls.
He's massive.
Got
They somehow managed to find the value in IP infringement.
the most obvious one
Yeah.
that comes to everyone's mind straight away when they think of IP is copyright.
Yeah. Bigger businesses will often leverage costs against smaller businesses.
Welcome to the IP Doctor. So it's the podcast brought to you by McDaniel's Law, and we specialize in intellectual property. It's our first one, so bear with us. But whether you're an entrepreneur, business owner, sole trader, or you've just stumbled across the podcast, hopefully you'll get something out of it. We are joined with my co-host, Kelly Hudson. And she needs no introduction. She's a trademark attorney, solicitor. She's the director at McDaniel's Law, which is a leading firm with the Legal 500. And she was a winner on Ant & Dec's Limitless Win as well. So welcome, Kelly.
Thanks.
I know
Thanks,
I get that in.
Yeah, I wasn't expecting you to get that in, so thanks very much.
Yeah, so what channel was it on?
3, ITV.
Yeah. So if you do want to go and watch the Limitless Win episode, get on the ITV Hub.
It's on ITVX, but don't watch it. It's not the best one. It's not the best Limitless Win. I think there's been better ones.
No, I thought
big
it was
losses.
Good.
It was quite good.
I thought it was good.
Yeah.
But as I say, this is our first podcast for McDaniel's Law. So bear with us, because if you lost at any point, it probably means that we are as well. But we've been speaking about doing it for quite a while, haven't we?
Yes, we have. And we think there's some interesting... Well, IP affects pretty much every facet of life, really.
Yeah.
So there's a lot we can talk about. And there's some interesting topics that people see. I think IP's in the media a lot more now. So people probably see and read about IP in the press quite a bit. So there's some very topical points about, that come up. But also, obviously, it is relevant to everybody's business, pretty much. If you've got a business, IP is relevant to it in some way. And you should be aware of it, because it's an asset that everybody can capitalize on. There's money to be made from IP, from your IP. And it's just about how you do that.
Yeah. So hopefully we'll be able to... We won't get through all of that today.
No.
On every point, but hopefully it becomes a series of podcasts if this one goes well, and then we can go from there.
Yeah.
But obviously we've named the podcast the IP Doctor.
Yeah.
And that's because we actually own a trademark for that name. We spoke about a lot of different names for it, but eventually we settled on the IP Doctor.
Yes. We should clarify, neither of us are doctors.
Yeah, we're not. So if you came here for a medical podcast,
you're not
I think you should look out elsewhere.
Yeah. So our surgery is very ad hoc, but yes, we do have a trademark for it. We've had it for a long time, and we've done tweets under the name, and we've done articles under the name. So this is us using our trademark in a new medium, but in the same way, to give legal advice. And hopefully people get something from it that's worth a bit of a listen. That's worth some time.
Yeah, exactly. And then hopefully moving forward as well, we can have guests on the show as well.
Absolutely. That's the plan.
So clients from ours, or if not a client and you've stumbled across it, please get in touch.
Yeah.
But it'd just be good to hear other people's views as well as ours.
Absolutely.
In that way.
And we should say thank you to our friends at Your Film who've helped us.
Yeah.
And I think Matthew is gonna be a guest at some point, isn't he? Because
hopefully
they obviously deal a lot in IP, and he's got some interesting things to tell us. So that would be a good one. Yeah,
exactly. I don't know why, but when you talk about names and everything, it just makes me think of the Starbucks and the Fredicino one, and all about that. If people don't know, essentially, the party came up with the name Fredicino, and Starbucks viewed it as infringing their rights of the Frappuccino. And it settled outside of court, but then it's a clear example of you need to do your due diligence and really try and prevent any of those matters coming forward than try and amend it at a later date and have to try and argue your matter. So make sure when you come up with a trademark, do your
Yeah.
due diligence.
Absolutely. And I think what was interesting about that for me was somebody else had originally trademarked Frappuccino. It wasn't Starbucks. They bought that
Oh, okay.
trademark from it was in an individual's own personal name, and they came and bought that trademark from him. And then obviously huge global success of Frappuccino. And there's possibly an argument that Frappuccino is going to fall into common use, which would then potentially make its trademark registration challengeable. Other examples are lino. Hoover's obviously a good one. And that's why a lot of brands are really nervous about, big brands get really nervous about names going in the dictionary
Okay.
and trademark words going in the dictionary, because it's an example of how they're going into common use. And some of them you'll see will be in the dictionary with a credit on there that it's trademark, because brands will push for that. But yeah, obviously the Frappuccino, Fredduccino, huge dispute. And then if you're in something like that with a company like Starbucks, you know, there's issues surrounding the corporate status of both the parties, and who's got more money to have.
Because it would have been interesting if that went the whole way to a court decision, and whether they actually would have deemed them as similar.
Yeah, and whether anyone was confused.
Yeah, exactly.
Realistically. Because that's one of the key tests. If the marks aren't identical, you need to be looking at whether anybody's confused or likely to be confused. But you know, some actual examples of confusion are always the best thing for lawyers to see. And you know, we've had a lot of them over the years. The trademark disputes, you see them a lot in the press now, and we see a lot of them. So there was a couple of very topical stories quite recently where people have named corner shops after supermarkets. I don't know if you saw, there was it Morrising? Was it Sainsbury's originally, and then Sainsbury's weren't happy and sent a letter, and Morrison said call it Morrisings instead, and they then made money out of the PR of that dispute by getting on the bandwagon and saying we're fine for you to call it Morrisings.
I think a lot of big brands used like IP disputes as promotion. Aldi's the best example, and everyone knows about the Caterpillar dispute.
And Aldi's social media team really made a huge deal out of that. And there's memes about Aldi's social media team put out there all the time. They did one the other day with Beyonce's Grammy.
Oh really?
So it was when she looked really shocked that she'd won the Grammy, and she was like sitting, and I see Aldi had taken that image, put it on social media, and the headline was "This is us when legal call us in for a little chat." And I thought it's really clever the way that the social media troll people is really clever. What they do in terms of the infringements, or you know, to some much smaller brands, not quite so clever, not great certainly for the smaller brands.
No.
But the way the social media manage it, especially when they're up against big players who are the same size as themselves, who could come back. You know, the Marks and Spencer's Colin the Caterpillar thing, from a PR perspective, it was quite hilarious. They sent a lorry in Oxford Street, parked it in front of the biggest Marks and Spencer's in the country, with a picture of their Cuthbert in prison behind bars, and then a big thing saying free Cuthbert, and did like a promotion. And Marks and Spencer's never really came back to make anything of the PR on it. But they really pushed it.
But they really kind of use it as their advertising.
Yeah,
don't
they do.
Because
they do. They make something
the
of
amount
it.
of money they would have to spend on a campaign to advertise, say, the Cuthbert the Caterpillar, and then they've just used it to be able to promote to that many people who are just reading an article, and they don't have to spend any money to do that. And they must look at the fees for the legal advice and legal representation is worthwhile.
Yeah, absolutely. They somehow managed to find the value in IP infringement. They managed to bring a positive value in being accused of IP infringement, and it's not great. There's been instances where they've come up against much smaller businesses, and we've acted for those smaller businesses on several occasions, and it's not great. And you know, the Thatchers, there's the recent decision with Thatchers over the Cloudy Lemon cider, which has just gone to the Court of Appeal. And Aldi lost on that. So, you know, they're going too far over the line. And actually, if it's a really small business, that can have a hugely detrimental impact. And we can't make light of that. But certainly when you've got the likes of the Marks and Spencer's dispute settled, and I've never seen, there's nothing out there to sort of tell us what that settlement entails.
Yeah.
But it obviously allows Aldi to carry on with this publicity that they've made of it since then, because they even put a TV advert out where there was just loads of caterpillars at a party, and then they had a massive fight. Did you see that?
I didn't see that one.
Yeah, it was like a Christmas
Was that
advert.
straight after or a few years after?
It was Christmas. No, it was a Christmas advert. You can probably find it online. There's like loads of caterpillars at a party. From all the different supermarkets, which is obviously they all do them. And so they all had the relevant names from the different supermarkets. And then they ended up having a massive fight because Colin goes for Cuthbert or something like that. So it's like people dressed as caterpillars, basically.
That's a good idea, that.
Yeah.
But as you referred to the small companies,
Yeah.
one of the main challenges with that is because a lot of the time they do have a good claim
Yeah.
on their side,
Yeah.
but then it's just the costs that come with it.
Yeah.
And I know the costs can be recoverable at a later date.
Yeah.
But for them to have to actually make that payment,
Yeah.
and it's not set in stone that they would be able to recover
Yeah.
them, it means that they don't go after them.
Yeah, absolutely.
But an
And-
example recently is that the Super Mario one in
Yes.
Costa Rica,
Yeah.
where essentially a grocery store
Yeah.
were trading under the name Super Mario.
Yeah.
And then Nintendo had a problem with that and brought a claim against them for infringing their rights in
Yeah.
the trademark. And I think they'd been trading since 2012,
Yeah.
the grocery store.
Yeah.
And I know the Costa Rican IP office
Yeah.
have just come to a decision
Yeah.
to say that they're able to still trade
Yeah.
because their Nintendo's trademark
Yeah.
doesn't cover the
Yeah,
sale
yeah.
of groceries and things like that. And that's an example of a smaller business sticking to it
Yeah.
and actually obtaining the result that they want.
Yeah.
And to be honest, they've been able to have quite a good bit of publicity
Yes.
from that, because
Yeah.
I think they have over 60,000 followers on
Yeah.
Instagram now as
And
well.
you can get there because there's like a Katy Perry in Australia who took on Katy Perry the singer in a trademark
yeah.
battle, and the lesser known Katy Perry won.
Yeah.
And that was obviously good for it. But it's hard because you quite rightly make the point about costs, and bigger businesses will often leverage costs against smaller businesses to put them off. So they'll drag things out. They'll make it as expensive as possible. They'll threaten a security for costs application if proceedings start. And it is really difficult, but as somebody who's smaller and as a startup, it's about making the most of the IP that you've got, doing what you can, get advice, and also like there's things like IP audits
Yep.
that are available through the UK Intellectual Property Office. So if you're a startup, or you don't have to be a startup, but even a smaller business who's got IP and you want to find out what it is, you can apply to them for a grant. They will give you a grant for a law firm such as ours, but there's a lot of law firms that'll do it, to go and get an IP audit done, where we assess everything that you've got, tell you what you've got, and we'll make some recommendations for how you can better protect your IP. So if you could get trademarks, if you need some commercial agreements, we'll go through everything, we'll put it in a report, and we give you some costings, and then you can use that to go and get further funding, either from, sometimes the IPO gives further funding, or you can apply for further grants. So we've had a few clients that have done that and then got, significant grants to then go and get some more trademarks. So there is help there for smaller businesses. And I think if you do end up in the unfortunate position where you're in litigation, it's about trying to make the best of it in terms of social media. So I suppose another good example is, do you remember maybe it's a year and a half ago now, Hugo Boss were going around suing, and they are, very prolific trademark defenders. So they will defend what they perceive as an infringement of their mark. And they went against a small business, and it was picked up by Joe Lycett, who then changed his name to Hugo Boss. And they backed down, Hugo Boss, and I think there was a settlement that came out of it, and it was resolved. But sometimes if you can build up enough media coverage of these things, it will help reach a resolution that can be more beneficial.
Yeah, definitely.
Than just sort of progressing. And that's something that, we've advised clients on in the past, where we've had clients who've gone to the newspapers. And I was in York out for the day on a Sunday years ago, and Neil rang me and said, "Did you tell this woman to go to the press?" And I was kind of thinking, I don't really want to say yes, because I don't want to admit if that's not been a good move. So just to clarify, Neil was my boss at the time, and so I said I might have done. Why? And he was like, because it's in the Independent and the Telegraph, and it had been picked up by one newspaper, and then a lot of the others had picked it up and followed on with it, and it managed to resolve the dispute really quickly. So that can have a really positive impact if businesses have got less money, like a bit like what Super Mario's done with the trademark issue they've had. And as you say, like that's picked up a lot of press. We've read about that, and it's over in Costa Rica, isn't it? So
well, it's everywhere.
Yeah.
And it only was last month, I think, it happened. So
So I bet he's had loads of people in the supermarkets since then.
Yeah. I wonder if he's had any people traveling across to go to the supermarket, because I'm
Maybe.
sure he had. Because what's the chippy in England that got really famous?
Oh yeah.
And everyone from over the world were traveling to it because it might be similar to that.
Yeah, there was. I can't remember what that was now, but there was a really famous chip shop, wasn't there?
Yeah, so something. Anyway,
we've talked about trademarks a bit, haven't we? And we've talked about how it's hard for small companies to go up against big companies, but the big companies don't always get it right, do they? So Nintendo's a perfect example.
Yeah.
And then I think you'd mentioned to me the other day the El Clasico thing, which is three big companies up against each other, but Real Madrid and
really with that, it was that Real Madrid and Barcelona both wanted to claim rights in the El Clasico name to stop the other one from using it.
But they didn't win, did they?
Neither if any of them were successful in that, I think it would have been quite a problem for the other party, because everyone uses El Clasico all over the world.
La Liga had the rights, didn't they? So
because they have a registered trademark from 23 as well, and you see more trademarks being registered within football as well. Like most recently, the Cole Palmer ones as well. He's attempted to register 5 marks, I think. One for Cole Palmer, one for Cold Palmer. Signature, but the two that are interesting are the figurative mark and the motion mark as well, because the figurative mark is just a picture of his face. And I know the EU IPO last year, 2023, they rejected a mark for a picture of a human face for a model. I'm not sure what her name was.
But there's an article about it on our website, isn't there? I'm sure there is.
There may be.
Yeah, I think there
so
is.
go and check on our website. But they basically were comparing the difference between uniqueness and distinctiveness. So they made the examples of things like Donald Trump's hair or Barbra Streisand's nose were capable of having that distinctiveness. But just the image of the model wasn't enough to be distinct. She had unique traits, but wasn't distinct. So it'll be interesting to see how they go with the Cole Palmer figurative mark, to see if they say that is distinct. Because with that EU IPO case as well, they tried to claim acquired distinctiveness because she had an international recognition for being a model. But they rejected that. But Cole Palmer would be to another level of that as well, because he's really famous, really prominent, just not only in the UK, the Premier League's watched everywhere. So it'll be interesting what they go with that. And also with the motion mark. Have you seen the motion mark?
Yeah, I have. I think
because it's his celebration.
Yeah.
Like going like that.
Yeah. Do you want you do it?
Like that.
It's got an action to it though, hasn't it? There's a video.
I think when he does it, he just
there's
goes
a video
like
on the IPO for it. I'm sure there's a video. Or he put a video out.
Yeah, and he just puts his arms up.
No, he goes like that, doesn't he? As if he's cold, like he's warming his
yeah, maybe.
Well,
it's that. I think when he does it in a match, he's more just
still.
Does it? Yeah.
Well, I hope he's applied for what he actually does then.
I can't see that being approved, to be honest.
I can't. But how would you assess infringement of it as well? Like, it would be really difficult. Is it because it's distinctive? Yes, you're basically saying it's distinctive of him. But then if somebody else did it, one, how are you going to know? I suppose, and two, how are you going to allege it's infringed? I suppose it would have to be for whatever classes of goods and services he's applied to cover, because trademarks cover a set number of classes of goods and services, and you pick the ones you want.
Yeah.
So say it's like sporting goods. I suppose he would say, well, if you had another footballer using his celebration to try and sell sporting goods, that's where it's going to come into it. But then, is he really well known enough for it? I don't know.
Well, I know he's applied to register it in a range of classes,
Yeah.
from like toys and games and everything.
Yeah.
So I'm not sure if he's thinking about selling memorabilia
Yeah,
and things
maybe.
like that. So that's why he wants it.
But then, like, does he want to license
He-
it to be used in like FIFA games and stuff like that? That's another.
Well, we won't
You
won't know.
won't know.
To
But
be
that
honest,
could be one thought.
but he included a disclaimer in there as
Yeah.
well. Yeah, registration of this mark shall give no right to the exclusive use of a sign compromising any person other than the person shown in the motion mark. So that makes me think that it's only if he
Yeah.
or someone who a doppelganger of
Yeah.
him, if it was
Yeah.
clearly identical, it would only be infringing if it's a depiction of him doing that action.
Yeah. I mean, it got some press, didn't it? Him applying for it, and there are other sort of motions where you could think there's probably enough there to say that's distinctive. So, like Usain Bolt's lightning bolt thing that he used to do is probably there, and I think other footballers will probably apply. It's just whether it's what is the value, and where they're going to get you with it. Because in theory, for example, you can register smell marks as well, olfactory marks they're called. And there are some on the register that are historic, but to actually get one now is another question. I mean, the IPO is opening up to all of these new kinds of marks. Sound marks are really common. You can upload digital files of sound files and stuff like that. And
there's one for Darth Vader's breath, isn't
Yeah,
there?
yeah,
Lucasfilm. Yeah.
yeah,
So
and a lot of companies have quite notable sound marks. Like
Yeah,
if you hear a certain pattern of notes, it makes you think of that business. So that's perfectly conceivable. It's just I think it would be really, really hard to with a motion mark. It's quite difficult. And where does the infringement line lie? It has to be something that, and this was the problem with smell marks, which the requirements being removed now. It was to be capable of being represented graphically. That's changed now, but that was always the problem with smell marks, was how do you graphically represent them.
yeah.
And that change has allowed motion marks to sort of come in, but obviously there's a video online of his motion mark anyway. I'm dubious as to the effectiveness of it, and someone will take it up and try and argue over it. We'll probably see some interesting court cases about it.
Yeah, it would be interesting. Are you aware of any motion marks that are actually videos of a person though?
Of a person,
or are, because the only ones I've seen, well, the main one's the Toshiba one in 2019.
Yeah.
And that's a graphic of like the origami.
You could get away with a graphic.
Yeah, but I'm not sure if there's any registered actually of a video of a person.
Not that I know of.
But it'll be interesting
Yeah.
to see what the UK IPO come
Yeah.
back with that.
Yeah, absolutely. Do people want to know what the other IP rights are? Possibly.
Yeah, so the most obvious one
Yeah.
that comes to everyone's mind straight away when they think of IP is copyright.
Yeah.
And you see it everywhere. And that can include anything from artistic, literal, musical.
Yeah.
So recently, this week, you've seen Warner Brothers come to an agreement with Cutting Edge to co-own their catalogue. I think it's worth about £1 billion of this catalogue where they have copyright in that. And although the test for copyright is if it's an intellectual creation of the author, you can transfer that right.
Yeah, of course you can.
So anyone who's made that music is now within Warner Brothers.
A huge value to it, isn't there? And it's a bit like the Taylor Swift thing where she's re-recording the albums because she hasn't got the rights.
Taylor's version.
Yeah. So they're saying she's going to announce a new version of, is it Red or something like that? I don't know. Is that later
I'm not too much of a
Taylor
Swift fan to know.
Taylor Swift fan, to be honest. I'm not big enough of a Taylor Swift fan, but but she's re-recorded them, hasn't she, and then released them. And you know they're worth vast sums of money. You do see this. The Warner Brothers ones, obviously, ridiculous sums of money involved. I mean, it will be worth that much money. And you see it a lot with like music back catalogues and things like that. There was one recently where somebody sold their pretty much entire back catalogue for an I can't remember who it was now, for an extortionate sum, and they do happen quite often. But copyright, it's really good because it just arises obviously automatically And as you said, it covers all these different things. And we probably should say, obviously, you can have more than one IP right in existing in a product or service or anything at any one time. So, I mean, we'll get copyright in this podcast because we've made it. We're the authors. So it's always there. It's a really strong right. Lasts for such a long time. Life of the author plus 70 years. So that's why you always need to know who the author is, especially if you're somebody who employs people and then you've got employees doing things for you. Assign it to a person, and yeah, I mean it's so valuable. And then so you had mentioned a case to me about Disney's Moana,
Yeah.
and there's a claim over that at the minute, and it's for the idea, isn't it? It's for the
Yeah,
idea
because
behind the
Buck Woodall, I think his
Yes,
name was,
yeah.
has brought a claim, and he initially brought a claim for copyright infringement when
Yes.
the original
Yes.
Moana came out, but then the court said that it had been too late.
Yeah, it was time barred, yeah.
But now because Moana 2
Yeah.
has come out, now
Yeah.
he's brought a new claim, so
Yeah.
it'll be interesting to see
Yeah.
if the court actually considers this one.
I mean, it's in the US, and it's hard because, like, certainly in this country, cases about TV formats, especially, they're not necessarily that well received. Like, it has to be something that's tangible, really. And there was an interesting one about a TV format the other week, which
The Shambles
Yes,
one.
the Shambles,
Yeah.
which related to was the later
It
show
was
called Shambles. It was, and there was a comedy format.
Yeah. Can't remember the name,
can't
but it
remember
was
the
the
name.
format of the show.
Yeah,
because
it was something
like
that was
a
shown on
comedy
Dave
club.
as well. Was it? It was
it
on
was a
Dave.
comedy club, and then
yeah.
the format of the show was like speaking to people
Yeah.
outside of that. And,
Yeah, parts of it were scripted and parts of it weren't.
and they were trying to claim copyright in the format.
Yeah, from the idea from an earlier show, and it failed. And it's difficult. So I think the guy's on a bit of a hard line with the Moana one. But if you look at Disney, for example, it's really interesting because obviously there's copyright in pretty much everything Disney's put out.
Yeah.
There's copyright in all the characters, and actually some of those copyrights are now coming to an end. Like, they've ended. So there was a thing where Winnie the Pooh went out of copyright, and then there was that Winnie the Pooh horror film that came out and stuff like that.
Yeah.
And then I think, is it Steamboat Mickey, the first Mickey Mouse, that isn't in copyright now, I think. I'm right to say that. But then you have to think about other things. So, and this is where IP rights overlap. So even though copyrights may have expired, Disney owns thousands of trademarks for like the likenesses of these characters, for the names of the characters, for all of the, anything remotely associated with them. And they maximize other IP rights in that way. And then they'll make, new versions of things. And part of that is Walt Disney said, didn't he, you have to make new versions of these films every so often for a new generation. But then there's new copyrights that arise in the new versions as well. So so it's really interesting.
What's interesting with the Moana one, though, is because for copyright to subsist, it can't just be an idea in your head.
No.
It needs to be on a bit of paper or somewhere in tangible form to rely on. But I think he's relying that he actually had a meeting with Disney in the past and provided them with creative works to show that he'd come up with this idea. And he's saying it's similar. So it will be interesting if the court takes this matter seriously, because it's in the Californian courts. To see what that evidence actually includes.
And maybe, they'll look at the storyboards and stuff like that if it gets to that point. I mean, that's certainly an IP in our jurisdiction. We have this notion of the idea expression dichotomy. And that's that fundamentally IP protects the expression of an idea and how that is manifested into something that is written down in tangible form. The idea itself is not necessarily protectable on its own, and you have to then put that down in a tangible form, be that in a copyright work, or you might file a patent for it, which we might not talk about today, but we might come on to patents in another episode, and we'll maybe get a patent attorney in to speak to people about that, or something that you file as a design, or which attracts a design right, or even trademarks when they're unregistered. You don't have to register trademarks. They are protected in the UK by passing off, the tort of passing off, and trademarks are great because for all businesses, even if you just start trading under your brand name, and you don't get a trademark. You're building a goodwill, and that goodwill is something that you can protect, through passing off. And that's what you're registering a trademark to protect, ultimately, is the goodwill that you've built in that brand, or that you want to build in that brand.
Yeah, exactly. When you're starting up as a company, though, you can build that goodwill, but
Yeah.
ultimately the best thing to do is register that trademark as soon as possible, really. Obviously, I know funds
Yeah.
are a concern for some people, but as soon as you register that trademark,
Yeah.
you don't have to prove use for 5 years
Yeah.
as well, if anyone did try and oppose that mark. So if you are a startup company or anything like that, definitely consider registering that trademark.
Absolutely, yeah. And it's not overly pricey in the UK. So a lot of people will come to us and they'll say, I want to register a trademark in the worldwide. And that's not something we would ever advise people to do. It's a ridiculous expense. And actually, do you need a trademark worldwide? Probably not. Not many companies start off and are instantly trading worldwide. You need to look at the jurisdictions where you're really trading and focus on those, because trademarks are territorial. So, if you're a UK business, you're probably trading in the UK. Some of our clients will say, actually, my main business is in the US. So they need a US trademark, but they need a UK trademark as well. And then you can extend trademarks as you go, in new jurisdictions as you go. And it makes the cost manageable. It's about making the cost manageable and something that, and we plan that with clients. We don't, you might think, great, this is a big filing and, we'll get all these rights in. But really, if you're not going to use them, and use in some countries is 3 years, not 5. So then if you're not using them in those jurisdictions and you've got this mark, it's vulnerable to be cancelled anyway. So you don't want that. That's a wasted expense, isn't it? So we always try and say to people, have the chat and then we'll work it out from there, because it's better to be strategic about it.
Yeah, because you need to commercially look at what you want to do, and especially the next 5 years or 3 years, especially when you're choosing the classes as well.
Yeah,
because
absolutely.
if you're not trading in a certain class when you're applying for the mark, but then you may want to move to that in the next few years, and you can see the company expanding and start to trade in that classification, it will be cheaper just to register that at the onset.
Yeah, it will.
And then you can start trading from there. Because as we say, if anyone did try and oppose, you've got 5 years. So as long as you start using it within those 5 years, it's fine.
Absolutely. So I think we've covered quite a bit, haven't we?
In terms of to be honest,
what we've talked about. We've rambled a bit, so I'm sorry if anybody feels like we've rambled.
I've got some questions if we want to go through that.
Do you want to do some questions? We can do some questions.
Let's have a look. So this one is from Meg, and it's, what is the most ridiculous dispute you have ever heard of?
I saw that one on the page, and I honestly don't know. There are some absolutely ridiculous disputes out there. There's a lot of them. Some the really ridiculous ones never get to trial, which is the funny thing. I mean, a lot of the IP disputes are, and you think, why is that in court? It would have no value, but they do. And I always remember that Rosanna Head-Rapson, who was one of the founders of our firm, she did her training contract at Alan Overy in London, and she had some exposure to IP, and she went to a trial that was about a kebab machine. It was about IP in a kebab machine.
Okay.
And that just sounds ridiculous, doesn't it? But there is a value in this stuff. So
on kebabs, what that's actually reminded me, but do you remember, I think it was last year, when Mbappe brought a claim against that kebab shop owner for using his IP because he compared the shape to Mbappe's skull or something like that, and he brought a claim to this small kebab shop for using his IP.
See,
and
that's ridiculous.
I think the person went on Instagram and was basically slagging him off, saying, have you got nothing better to do than come after a small kebab shop owner? That's pretty ridiculous.
There's a lot of them that ridiculous. And since I've done quite a lot of trials relatively because we don't get a lot of IP, doesn't often end up in trials. And the variation in the trials that we've done is huge in terms of products. So furniture, was one. Two on furniture, 2 or 3 on furniture actually, and then we've done some about fashion. We've had some that relate to the drafting of contracts and confidential information and that sort of thing. Really varied, and that's why I enjoy IP as a solicitor, because I think when you do a law degree, I don't think anybody goes into a law degree thinking IP is the way to go. For me, I didn't. I like used to watch TV shows and think like crime's really interesting as an area.
Yeah.
It's criminal cases are so interesting. It's just in practice, it's can be quite depressing and hard going. So then you get to university and you get told about commercial law, and that's probably what most solicitors do. And I was always really interested in IP, even from early on, because it's so varied. The case law is so varied. It covers so many different business areas, and we get to learn about these business areas when we go in there and we do these cases. So I learned all about how boots are made in one case that we did for our clients, Fairfax and Favour.
Yeah.
And we've worked with those guys for a long time, and that was brilliant. That was great, and then I've learned about the different wood that you use when you make furniture manufacturing and stuff like that. So to some extent, none of these cases are anything you would expect. But yeah, they're really ridiculous.
You're having
ones.
to pick up skills that you would never
you would never expect.
that you would have to.
Yeah.
One day you could be looking at furniture and the different dimensions and things like that.
Yeah.
And the next day you could be looking at some music or anything
greetings
like
cards or something like that.
Greetings cards.
Yeah.
So it is a really interesting area.
It is.
Because as you say, I think when most people go to uni to study law, people have a misconception of what they're going to go in to, especially because of programs like Suits and things like that. They think that that's what it's going to be on a daily basis. But to be honest, I would hate to be the firm like Suits.
I mean, I would like, there were certain areas that were never for me. A lot of people would like to do, for example, family law. I was never particularly interested in that. It's very much about something that you think you can sustain an interest in for your whole career. And the reason I like IP is because, as I say, it's really varied, but then also the clients are really varied. So some of our clients might just be sole designers on their own, and some of them are much bigger businesses, but there's that nice there's real variation and a mix of the people that you deal with, and that's lovely in itself, because you really get to see all different facets of business, and that's really nice. But ridiculous cases, it's hard to pinpoint them, but there's been some. I'm sure there's
one
been
that
many.
comes to my mind, which it wasn't actually a ridiculous case, but was when the owners of Brewdog changed their name to Elvis for the Elvis juice when Elvis company came after them for that. And I know they changed the name to Brewdog's Elvis juice eventually, but I'm pretty sure that's still ongoing, the whole matter.
Yeah, I mean, Brewdog's had a few issues. They sued Aldi a while ago, and then I think they ended up supplying into Aldi. So that was a commercial
good outcome for them, to be honest.
Yeah, so they've had a few.
Another question. Yeah. This one's just a bit of a fun one from Luke, who says, if you could own the copyright for any song, what would it be?
It's out of copyright now, but I would pick Happy Birthday.
Would you?
Yeah.
Yeah,
because you get royalties all the time, wouldn't you?
I think I would pick Mariah Carey at Christmas.
Yeah, that would be a good one. That would be a good one.
Because every year you would know that you just had an uncovered stream of...
Yeah, although maybe it's Wham's Last Christmas, because I think actually that's been my favourite Christmas song the last couple of years.
Yeah.
So, that film, what's the film? Is it about a boy where Hugh Grant, he basically lives off the fact that his dad wrote a famous Christmas song, and he lives off the royalties he gets every year.
Oh, really?
Like, he's got no job. He's like, he just lives off the fact that he gets royalties off the Christmas song every year.
Is that a Christmas film? Yeah.
No, it's not a Christmas film. It's just that he is in the film, and the plot is that his dad wrote a really famous Christmas song. So he just is a bit of a layabout who doesn't need a job because he can live off the royalties.
I haven't seen that one. I'll have to look into it.
Yeah.
All I think of when you think of Hugh Grant and Christmas is in Dancing as the Prime Minister in Love Actually.
No. So that in that one, he just lives off royalties. But yeah, you would want to pick a good song that gets played a lot.
Yeah, definitely.
So, and what else? What other one would be good? Like something they play in sports stadiums or something a lot.
Champions League theme.
Probably you could go for that Jess Glynn song that Jet 2 use all the time. She must get some royalties off that because
Do they still use that,
everybody
though?
hates it so much
Yeah,
now, don't they?
when everyone's clapping after.
Yeah.
Well, whether you do clap or not.
There
But
was something in the paper a while ago where some woman had her flights cancelled for coming home from a holiday. She was really stressed and she rang Jet 2 and it was just Jess Glynn on hold for about 4 hours, which was awful. But yeah, there must be some royalties on that because it's been well used.
Is it still used now?
I'm fairly sure it is, yeah.
But yeah, she must be loving that if Jet2 are just using it on all of their flights and all of their phones, and it's just going through. But I think we've been through quite a lot, haven't we?
Yeah, I think we've done quite well. What do you want to? I'll ask you a question.
Okay.
Which is from Andrea. Which celebrity has the strongest personal brand? Do you think? Who's got a good personal brand?
I think one of the first ones that will come to everyone's mind is The Rock.
Do you think?
I think it is.
Right. Okay.
He's the most unique.
Yeah.
Well, one of the most unique.
Yeah.
Are
you a big fan of The Rock?
Not really, but I think he's got he is unique. He's massive.
Yeah.
Bald.
He's massive.
Got loads of tattoos.
Yeah.
Has loads of companies.
Yeah.
That I'm sure he has. I haven't checked, but I'm sure he's registered all of his IP rights and has loads in all of that.
Yeah.
And he's in an enormous amount of films.
Yes.
Isn't he the top grossing actor?
He is, isn't he? Yes. I think he is.
All time.
Yeah.
Well, not all time, but certainly every year. I think he's.
Yeah.
If he's not top of the list, he's up there.
Yeah.
So, I think I would say The Rock.
I think the Beckhams have got a good brand as well, especially with the two of them combined.
Yeah, definitely.
And they make the most of that. And a lot of that, they've got a lot of trademarks between the two of them. There's a lot of brand management that goes on there. So I think they're quite a good shout. And I think to be honest, I tell you who's I think's done really well with the brand over the last few years is the royal family. Have really upped their brand.
Yeah.
Especially with the use of like the younger members, sort of like the Prince of Wales and the Princess of Wales as they are now. They have a really strong brand image, and certainly when you get royal warrants and things, and if they use a company's product, or for example, Kate Middleton wears a hat that somebody's designed, all of a sudden then it's everywhere, and I think that's had a bit of the royals have always had good brand value, but I think that's had a surge in recent years, and it's been quite well managed.
Do you think that's maybe because in the past all of it's been to do with the Queen, and then
possibly
the Queen's no longer with us, so now they've had to be forced to up their brand and the market presence and things like that?
Yeah, possibly. And I think that with the younger generation of royal family members, there's different ideas about sort of interacting with the public and how you manage that brand, and there's more commercial awareness of it now, and I think they've done quite well with that. And I mean, even the king as he is now, the Duchy of Cornwall brand as a brand is huge. It's worth an absolute fortune. I read the figures for what it was worth a while ago, and it's colossal. Absolutely colossal. It adds absolutely huge value to his personal wealth, and that was managed very effectively when he was Prince Charles. So these, I think people think images about status and all the rest of it, but actually it's monetized so heavily, and it's absolutely colossal value to it, and celebrities really have cottoned on it, certainly now, cottoned onto it a lot more. And they make a lot more from
definitely.
it. Yeah.
Cool.
I think, are we good?
I think we're good.
I think we've covered it all.
I think that's it for our first episode. I hope you've enjoyed it. I thought we did all right, to be honest.
I think we've not been too bad.
Yeah, so hopefully there will be another one.
Yes.
If we watch this one back and think it's worth another one. But I'm sure there will be. So make sure, I'm not sure what platforms this is going to go out on, but whatever platform you're watching, make sure to follow, subscribe. If you do want to be a guest in the future, make sure to get in touch. But thank you very much. And
thanks for joining us.